Welcome to Employment Law This Week. I'm George Whipple. The California Supreme Court has picked a test for whistleblowing retaliation cases. After almost 2 decades of uncertainty around the question, the court has directed lower courts to use state statutory law as the framework for deciding this type of retaliation case, rather than the federal burden-shifting McDonnell Douglas framework used in discrimination cases. This means that employees only have to prove that their whistleblowing was a contributing factor to their termination, and not that the employer's business reason was pretextual. Under the law in question, Section 1102.6 of the California Labor Code, plaintiffs must show that their whistleblowing was a contributing factor to the adverse employment action. The employer must then show that it would have taken the same action regardless of the whistleblowing. Under the McDonnell Douglas standard, the burden then shifts to the employee to prove that the evidence was a pretext for the adverse action. But Section 1102.6 contains no such requirement. New York City employers are reviewing job postings in preparation for new pay transparency rules. Starting May 15th, New York City employers must include a minimum and maximum salary on all New York City job postings. Under the law, employers with 4 or more employees must display good faith salary ranges for all New York City job, promotion, and transfer opportunities. Failure to do so will be considered an unlawful discriminatory practice under the city's human rights law. Federal agencies are ramping up enforcement efforts in support of President Biden's labor agenda. The Department of Labor recently announced its Wage and Hour Division will hire 100 new investigators to step up compliance enforcement, with more hiring planned later this year. In addition, on Monday, the DOL released the White House Task Force report on worker organizing and empowerment. The 45-page report offers almost 70 recommendations, most of which are focused on increasing union membership in both the public and private sector. And the NLRB General Counsel's Office announced a new initiative aimed at protecting union organizing activity. The agency will seek injunctions against employers who threaten or attempt to coerce employees during union organizing campaigns. That's it for this week. Thank you very much for watching, and we'll see you next time.